Greetings to everyone who has joined us today. My name is Colleen Gwazani. I am the coordinator at the Institute for Integrated Transitions. I work mainly on our Zimbabwe project, and I'm also supporting our initiative on Apex court appointments, which is the subject of our event today. And I'm joining you from Harare, Zimbabwe. I am indeed delighted to welcome you all for this second webinar, which is part of IFIT's year-long series of events and initiatives to celebrate our 10th anniversary and explore peace-building innovations in our local work. For the next 30 minutes, we will be exploring the key structural characteristics and roles that are played by Apex courts in a democratic society. We'll also explain how IFIT's initiative on Apex court appointments is filling the current gap in global guidelines and criteria for the selection and appointment of judges to these unique courts. So today I am pleased to be joined for this conversation by two distinguished colleagues. We have with us today Professor Sujit Chowdhury, a Canadian-based barrister and internationally recognized authority on comparative constitutional law. He is also a specialist legal practice for public and international law. He is also the head of chambers of Haki Chambers Global. Professor Chowdhury is also the co-convener of the initiative on Apex court appointments, which IFIT is undertaking in partnership with the Center for Constitutional Transitions. This initiative is being supported pro bono by King and Spalding. Also joining us today is Justice Catherine O'Regan. He is the inaugural director of the Moderator Institute of Human Rights. Justice O'Regan is the former judge of the South African Constitutional Court and a member of the high-level advisory panel for the Apex Courts Initiative. So welcome, Justice O'Regan, and welcome, Professor Chowdhury.
Thank you. It's a pleasure to be here, Colleen.
Yeah, thank you, Colleen. Delighted to be here.
I will first turn to you, Professor Chowdhury, and I'd like to invite you to tell us a bit about the initiative on Apex court appointments. How did this initiative come about and what is the goal? Also, maybe just to provide some clarity as well to some of our audience, what do we mean when we talk about an Apex court?
Sure. So first of all, an Apex court on our definition is the court of highest appeal for constitutional matters in a jurisdiction, and so an Apex court is either a specialist constitutional court or a generalist Supreme Court. And as Kate, I know, will discuss, the Apex courts with a constitutional mandate to enforce the Constitution fills a special kind of role in a constitutional democracy, and she'll kind of address what that role is and how it shaped this project. Let me talk a bit about how we got this project off the ground. And so, as with good research, this project began in the field, and it emerged from Zimbabwe in a very practical context. And so a couple of you, as you know, IFIT has a very long-standing project in Zimbabwe, and has a Zimbabwe brain trust that it supports to provide technical and other advice to constitutional reform processes in that jurisdiction. And in the course of its work, the brain trust was approached to offer advice on appointments to the Zimbabwean Constitutional Court, because a number of seats had opened up. And there is a Judicial Services Commission in Zimbabwe that has a mandate legally to recommend appointments to the court, and the Brains Trust was asked to propose a criteria that the commission might consider. And so I was brought in to work on this with IFIT, and what we quickly discovered is that there wasn't a standard instrument, kind of a guideline, either a regional one or an international one, that spoke to directly to the issue of apex court appointments. And so we convened a panel, an ad hoc group of distinguished jurists from across the SADC region, including Kate, both sitting and former jurists, to ask for their guidance on what criteria might look like. And we came up with a list of criteria, and we sent those on to the JSC in Zimbabwe. And then on further reflection, we decided that it would be a good idea to launch a global project as a partnership between IFIT and the Center for Constitutional Transitions, which I direct, to develop a set of global guidelines. And the reason is just what I said before, that there are lots of guidelines internationally which are soft law instruments, many of them generated through UN-led processes, but they don't. They're instruments that address judicial appointments, but they don't address apex court appointments. And in our view, those existing instruments, although valuable and important, could be usefully supplemented by a new instrument that addresses two sets of issues. So first, those instruments they focus overwhelmingly on questions of procedural fairness and individual merit, and they largely omit the question of character, which emerged from our consultations with SADC jurists as being quite important to apex court appointments. And then the second is that the guidelines that exist at the international level are generic in that they apply to all levels of court, and they aren't specifically tailored to apex courts, which have a unique set of functions in a constitutional democracy. And so the point of this project is to generate an international document that can then be regionally contextualized in SADC and elsewhere, that addresses the unique issue of appointments to an apex court.
Okay. Thank you so much for that explanation, Professor Chowdhury. And I'm just going to turn to you, Justice O'Regan, to share some of your experiences. I know you were one of the first judges to be appointed to the Constitutional Court of South Africa in 1994 at the end of apartheid, which I think is really amazing. So from your experience in South Africa, but not just South Africa alone, but also from your assessment of other contexts, what would you say is the role of an apex court in a democratic society or in societies that are going through periods of democratic transition?
Well, thank you very much, Colleen. So, I mean, I think it might be helpful to step back a little bit from South Africa to start off with and realize that around the world, really since the end of the Second World War, we've seen an explosion of constitution making in which we have seen significantly expanded roles for courts being crafted in a range of different contexts, many of them transitional. And so there's no one role that apex courts, as Sujit has defined them, play, but just to give a couple of examples. So whenever you establish a federal system where there is an allocation of powers between central government and provinces or states, you need a tiebreaker where conflicts arise, and that is in most federal systems conferred upon courts. Or when you entrench a Bill of Rights, there needs to be an institution that will give effect to the rights in the Bill of Rights. And that often falls, particularly the final interpretation or final appeal in those cases, falls upon apex courts. And sometimes there are others. So the South African Constitutional Court had a very special role in relation to the two stages of constitution making, where the Constitutional Court had to decide whether the final constitution that had been adopted by the Constitutional Assembly, which was the democratically elected parliament sitting as a Constitutional Assembly, did comply with certain constitutional principles that had been agreed in the democratic transition. So these different roles, however, can be seen as being all of them relating in some ways to three levels of society. Firstly, the relationship with the other branches of government. As we know, classically from the separation of powers, courts are one of the three branches of government, and the roles of constitutional courts in apex courts in interpreting constitutions means very often that they have an important role in determining and even having oversight over the two other key arms of government, that's the executive and the legislature. Secondly, apex courts have a very important role in relation to other courts and to the legal system generally, because even where there's no formal system of precedent, the decisions they reach are enormously influential in the legal system in determining what the interpretation of the Constitution is. So they're very important in relation to courts and the legal system. And then thirdly, of course, they're very important in relation to ordinary people, people who have rights under the Constitution, who need to claim them. Apex courts are in many cases the last appeal in relation to those claims. So in the South African context, the court has used as its logo the image of a tree with people sheltering under it. And the idea that that image is communicating is that the courts are there to protect people within the constitutional framework. So these are three very important relationships that that apex courts have within a system. And then one needs to recognize that there are certain things that courts do, which are apex court do, which are very important, some of which I referred to already. So they're generally the final, they have the final word on matters of constitutional interpretation. They're not the only interpreters of the Constitution. Obviously, both legislators and executives and ordinary citizens and lawyers interpret the Constitution all the time and have to do so. But binding interpretations tend to come from apex courts. They're obviously also very publicly visible. Again, in the South African context, you find the Constitution actually often represented by the logo of the court. And the court, members of the court, and particularly the presiding judge, the Chief Justice, has particular roles in the separation of powers. It's the Chief Justice who swears in the President and members of Parliament. And you often see this representation of the third branch of government through the Chief Justice or the apex court, symbolized in the roles that are played by the apex court. The result of all of this means that the apex courts, of course, are very much in the public eye and also very much at the vortex of political pressures within a society. And that means that the people who populate those courts have got to have particular qualities in order to be able to be seen to be impartial in political disputes that arise, to be seen to be able to decide the cases competently and within a reasonable time, and for lawyers to see them as able lawyers. So all of this means that the character of judges on the court and the qualities and expertise is important. And then finally, to note that an apex court is nearly always a multi-member court. That means you have to be able to be somebody who works with other people. Lots of lawyers are not necessarily good at that. It's a team exercise. And so that's a particular character of an apex court, which is different, for example, to an ordinary judge in a high court who would often sit alone.
I mean, that is very interesting, Justice O'Regan. You touched on some very pertinent responsibilities that are quite unique to apex courts. You touched on their role in interpreting constitutions, but also the fact that they are the final court of appeal. And maybe just to follow up as well, and maybe to dig deeper into this, I know you have referred to some parts of this already, but what else would you say some of the structural characteristics of apex courts that make them different from, I don't want to call them ordinary courts, but different from other levels of courts beyond what you have just shared with us previously?
Well, I mean, just to repeat is that I do think it's the fact that they sit in panels is a very important structural characteristic, that they have the final word. And that is the final word vis-a-vis the other branches of government, also vis-a-vis other courts. Something perhaps we don't often think about as lawyers, but for an apex court has to consider what courts we often call the courts below or lower courts, but they're often very senior judges in courts of appeal and and high courts, very experienced lawyers, very experienced judges, have decided and then consider on appeal whether their decisions are correct. That particular role means that they have to instill confidence in those lawyers and judges whose work in some ways they are reconsidering on appeal. And that is a very important part of being an apex court. So they've got to have confidence of the other branches of government, the executive and the legislature. They've got to have confidence of the people, but they've also got to have confidence of lawyers and other judges within the legal system, because of the fact that structurally they sit at the top of the legal system. The very word apex makes it clear that they are the final court of appeal, and therefore that means that when they hand down their appeals, they've not only got to persuade the litigants before them, but all the other judges who heard that matter before have got to say, well, maybe they disagreed with me, but I can see why. And I think that the way in which they've disagreed with me, they've done so competently, even if I still think I was right in the first place. That's a very important part of being an apex judge and being part of an apex court.
Interesting, Justice O'Regan. I mean, just by considering these characteristics and these roles alone, clearly constitutional courts have this big and sometimes quite controversial role in advancing and safeguarding a nation's democracy. I was just reflecting as well that we saw this pertinent role in Zimbabwe during the contestation of the 2018 presidential elections, and we also saw the same happening a few weeks ago with the elections in Kenya, and a few days ago with the elections in Angola as well. And these incidents just emphasize this unique and important role that apex courts and this apex court initiative is hinged on. I'd like to shift back to more detail on the apex court initiative itself. Professor Chowdhury, what would you say are some of the judicial appointment criteria that this initiative is currently considering to be part of the future guidelines for appointment of judges to apex courts?
Sure. So we are working on a draft document, and the document will consist of a set of guidelines that have take one of two forms. Either they'll state kind of a rule or a principle or a criterion, and kind of justify it, but for other issues, we've decided that it's better to set out a range of options and to discuss the pros and cons of these options. And the reason that we've landed on that second approach for many issues is that there's not one right way to address an issue, and there are often very specific questions of legal culture and regional identity that shape certain institutional practices. So, for example, Latin American courts and Commonwealth courts, particularly in sub-Saharan Africa, there's sort of regional patterns of behavior, or European continental courts. And so rather than kind of try to impose a single option or suggest a single option for a very diverse world, we thought it's better to set out a range of options. So the guidelines are going to fall under four headings, or be organized under four headings. And those four headings are the structural role and characteristics of apex courts that speak to some of the issues that Kate has spoken about, appointment criteria, appointment processes, and then conditions of service and tenure. And in respect of the first heading, the structural role of characteristics of apex courts, the guidelines are going to set the stage for why the instrument exists, and will speak first on the one hand to the role of an apex court within a democratic society, including in transitional contexts, and so and its relationships to other branches of government, to other levels of court, and also to the public. And then it'll also address the unique structural features of apex courts, which Kate listed, that they provide the final word, they provide thought leadership, that they're the most visible representative of the country's judiciary. They're under political scrutiny. They address high stakes disputes, and they also operate in this team format, as she put it. And then after setting the stage with that description of the function of apex courts, the guidelines will then turn to appointment criteria, and those appointment criteria fall into three categories. The first are individual criteria of inclusion. The second are individual criteria of exclusion. And the third are collective criteria of inclusion or questions of diversity. And so let me address those quickly. So with respect to individual criteria of inclusion, we will be leading with a criteria of character, which are largely absent from the existing guidelines and judicial appointments, but which have emerged in both our consultations with senior jurists in the SADC region, but also internationally, as being quite a fundamental importance to apex court appointments. And so the criteria of character that we are proposing will be integrity, judicial temperament, impartiality, independence of thought, intellectual openness, courage, professionalism, and the ability to collaborate and engage in dialogue with others. And then the merit-based criteria will be familiar to in some respects, so exceptional legal qualifications, a certain number of years of relevant experience, but also demonstrated political acumen in the sense of having broad experience and awareness of the political context in which the court operates. Although, to be clear, not to suggest that the court should be operating in a political fashion at all. So there's a difference between political acumen and an alertness to the political stakes as opposed to being a political actor. And so it's political acumen that we think is important. Then, with respect to criteria of exclusion, there are certain categories of criminal conviction we think should exclude individuals from apex court appointment, but we don't want to be overly broad in that definition, particularly because of the transitional context in which many of these courts operate, and individuals might have faced criminal prosecution because of their political activity. And either prosecutions for political activities themselves or criminalized prosecutorial decisions, or politicized prosecutorial decisions in respect to ordinary crimes because of their political activities. And we don't want good people who've been on an opposing side of a political conflict to be excluded because of a criminal record. And in addition, we think there ought to be kind of some minimum age criteria, but also maximum criteria, because to have a mandatory retirement age. And then with respect to collective criteria of inclusion, I think here is where we've had a lot of very productive and interesting discussion. And I can say that as a global practitioner who's reared within and practices out of North America, it's been very helpful for me in particular to have robust exchanges with my colleagues. So questions of diversity are profoundly important, and representation in how we design institutions. As Kate will know, right now there's a debate in the UK about the lack of diversity in the UK Supreme Court because the court filled 2 vacancies with retired white male judges, when there are many highly qualified women and judges of color on the Court of Appeal who could have been advocated. And so we think that questions of inclusion or representation or diversity on the basis of gender, race, ethnicity, religion, disability, or sexual orientation are important, but they aren't the only issue. And so a large number of the members of the expert panel that is assisting us in framing these criteria have highlighted the need for viewpoint or ideological diversity. And so one of our experts put it this way, that, listen, in an autocratic regime, there might be judges who represent different axes of diversity, gender, region, religion, ethnicity, etc., but they might all think the same way. And so that's not real diversity, right? What you need is a court that represents different political or ideological currents or approaches to the nature of the state and constitutions on the court. And that's particularly important in a transitional context where different political interests will be represented through parties, will be settling disputes on the court, and it's important they accept the judgments as legitimate when they lose, and that the losers comply with judgments, and they're more likely to do that if they see a court that represents a broad variety of viewpoints and ideologies. And so I'll refer classically to the first South African Constitutional Court, which was an independent court, but nonetheless there were judges on that court who had been identified or nominated by different parties, and that was important for its legitimacy. Regional or place of origin diversity is very important, particularly in federal states or regionalized states, where power has possibly been concentrated in one region at the expense of others. Personal and professional experience diversity is important too. And so what's nice about apex courts is that you can have different types of lawyers. You can have career judges. You can have private sector lawyers. You can have academics. You can have government lawyers, NGO lawyers, people who bring different experiences. And that's also helpful in producing a collective mindset or approach or sensibility to the types of cases that come up. So I think questions of diversity have been very important for us. And I think we've broadened the lens, quite frankly, of what we think diversity meant, at least when I came into this project, in a very helpful way. With respect to applications, Colleen, did you want to cut in there, or?
Yes, I was also just, as you were concluding, Professor Chowdhury, that, I mean, beyond the criteria, it's interesting that these guidelines, beyond the criteria of character, they'll also touch on issues of diversity of the court and issues around the tenure of apex court appointments and the age limit as well. Yes. Because these are becoming very pertinent issues threatening democracy in a number of countries. And when you're speaking, it also took me back to our experience in Zimbabwe in 2020, when there were arguments around the extension of the tenure of the Chief Justice, who had to retire because of the age limit. And I'm just going to shift, I'm conscious of our time now. I'm going to shift back quickly to you, Justice O'Regan. For the next 1 minute, could you please briefly share with our audience? I know we have touched on some of the current global trends and the experiences of some countries, but could you please briefly share with us why you think this initiative is timely and important, especially considering trends in judicial systems and around the independence of the judiciary?
Well, thanks, Colleen. So I suppose very quickly it relates to, if we think of the expanded role of courts in many parts of the world, in many new democracies and even in old democracies, it's very important that when courts perform their roles, they do so in a manner that demonstrates integrity, competence, and that people have confidence in, that people can see that there's impartiality. And getting the appointment process right is very important to that. It's not the end of the road, but it's very important to that. So I think that's why this is so important at the moment.
That is very true, Justice O'Regan. And Professor Chowdhury, in 30 seconds, would you want to share with us any final reflections?
No, just that we're trying to produce a set of guidelines that will be put into practice. That are meant to help. And so the ultimately they're meant to be picked up in the field. And the reason we've engaged in this type of a process by putting together a terrific expert advisory panel with vast experience is to produce guidelines that matter. And ultimately the true test of whether we've been successful is whether the guidelines become a soft law instrument that is referred to and relied on in constitution building processes and reform processes around the world, and we're hopeful that it will be.
Yeah. Well, I'm sad to say that this brings us to the end of our discussion. We had 30 minutes, but I felt like we had only 10 minutes because it was just interesting listening to your thoughts and opinions. Thank you so much, Justice O'Regan. Thank you so much, Professor Chowdhury, for being with us today and sharing your insights.
It's a pleasure.
Yeah, thank you, Colleen. So thank you, and thank you for all of your work on this initiative. It's been wonderful.
Hear, hear.
Thank you so much. And
thank you for attending.
Yes, and a special thanks indeed to our audience for joining today's discussion. We look forward to seeing you at future events. The next event within our 10 Peacebuilding Innovations series will examine IFIT's First Street Initiative. It's going to take place sometime in October. We are going to share with you an invitation and details within the next coming weeks. So thank you once again. We appreciate your time and please keep well.